There is a type of enforcement guidance called the no-action letter. It appears in no statute Congress ever passed, and it has been shaping the rules of American finance since the 1970s without a single public vote. It carries the weight of federal law. It is not federal law, and no one, not Congress, not the courts, has any mechanism to undo it. Here is what it literally is. When a company wants to do something that might or might not violate federal securities law, it writes to the Securities and Exchange Commission staff. The staff writes back. If they agree the company's plan is probably fine, they say so. They say the staff will not recommend enforcement action. That response is a no-action letter, not a ruling, not a regulation, not a statute, a letter from bureaucrats. But every major financial institution in this country treats that letter as a legally binding green light. Lawyers bill six figures to obtain one. Entire business models are built around their conclusions. The SEC has issued thousands of them across decades, shaping markets worth trillions of dollars, with no congressional authorization, ever. This is the part that changes how you see the SEC. The no-action letter was never created by law. There is no section of the Securities Exchange Act of 1934 that establishes this process. There is no vote in the congressional record, no floor debate, no committee markup where members of Congress agreed that agency staff should issue private letters that effectively become the rules of American markets. The practice grew from internal agency habit. Staff attorneys began writing informal responses to company inquiries mid-century. It was convenient. It reduced litigation. Companies loved certainty, even informal certainty. By the time anyone thought to ask whether Congress had authorized this, the practice was so embedded the question seemed almost quaint. The SEC formalized the process through its own internal rules, not through Congress. They built the infrastructure. They published guidance. They never asked for permission. No one noticed, and no one voted. Here is who controls it now. Not the 5 commissioners who lead the SEC, not Congress, not the courts. The Office of the Chief Counsel, division staff, people whose names will never appear in a headline. Those staff attorneys decide which letters get answered, which get ignored, and what the answers say. A single staff attorney can effectively issue an exemption from federal securities law for a transaction worth hundreds of millions of dollars. No commissioner vote required. No public comment period. The 2019 turnkey, yet no-action letter opened a door for certain cryptocurrency token offerings. 2 staff attorneys wrote it. No one elected them. And here is what this means for ordinary people. And here is the part that should actually worry you: it's completely legal. When a company structures a financial product, an investment vehicle, a securities exemption, it does not only read the law, it reads the letters. Not because it has to. Because the alternative is waiting years for an enforcement action that may or may not arrive, spending tens of millions in litigation and still not knowing the answer. The letters are faster. They are cheaper. They are final in practice, even when they are not final in law. In 2020, a series of no-action letters effectively governed how broker-dealers could operate robo-advisory platforms, automated investment services used by millions of retail investors. Congress had passed no law about robo-advisors. The SEC had issued no formal rule. Staff attorneys wrote letters. The industry followed the letters. Millions of Americans' retirement accounts are managed under rules no legislator ever approved. And when letters conflict, when a 2015 letter says one thing and a 2021 letter implies another, companies fight over interpretation. But you cannot take a no-action letter to court. Courts have held specifically that no-action letters are not final agency action. They are unreviewable. You cannot challenge them. You can only follow them or be prosecuted for not following them. Remember, no one voted for this, and here is why no one can undo it. Congress could theoretically prohibit the SEC from issuing these letters, but every company that built its operations around existing ones would face immediate legal uncertainty. Markets would freeze while lawyers litigated what old letters meant without the mechanism to replace them. The courts cannot strike it down because the letters are not reviewable. There is no standing to challenge a document that is not a final agency action. The SEC itself could stop issuing them. But the practice is now structural. Stopping would generate its own disruption. The mechanism locked itself into permanence by becoming necessary. That is not an accident. So what does this tell you about everything else? Every major federal agency operates informal guidance systems, the kind that shape conduct and create de facto rules while existing entirely outside the Administrative Procedure Act. The EPA does it. The FDA does it. The FTC does it. The no-action letter is simply the most visible instance of a governing architecture built deliberately in the gaps between statutes, not illegally. That is the precise point. These mechanisms are not illegal. They are unaccountable by construction. The official law you can read is not the only law that governs you. There is a parallel layer of administrative practice carrying equivalent force, facing scrutiny from no one. You were never told because there was nothing to announce. The question worth sitting with is not why agencies built this. It is why the people who designed the oversight system allowed it to fill in so completely, so permanently, that reversing it would cause the very disruption it was built to prevent. Ask yourself who that outcome benefits.